I want to thank you all for coming, and hopefully we'll make this important, interesting, and need I say even a little bit interactive. I'm Sam Visner. I have the honor to chair this this panel today. I'm really grateful to the university for making this event happen, to our panelists who are really quite distinguished, to the sponsors of this event, including my own company, ICF International, where I lead our cybersecurity business, and most of all to you, the attendees. I will be facilitating the discussion, but the intellectual powerhouses are all to my right. By way of introduction, I'm the Senior Vice President and General Manager of Cybersecurity and Resilience at ICF International. We do about $70-odd million a year in cybersecurity business, about 350 people, and I'm really proud of what they do, but I also am an adjunct professor here at Georgetown University, where I teach the Cybersecurity Policy, Operations, and Technology course within the Science and Technology and International Affairs program of the School of Foreign Service. So again, on behalf of my company as a sponsor, and most of all on behalf of the university, I welcome you. And I'm also an adjunct here, class of 1970, when dinosaurs. So enough of that. We have assembled a group of people here I think are truly distinguished, both in terms of their accomplishments and in terms of the breadth of their experience. We have people who understand government and the public sector, the art of understanding where industry needs to go, those who are expert in communicating these issues and guiding others, those who have distinguished backgrounds in public policy, computer science, public service, and the media. It's sort of amazing that we managed to get sort of 90% of the world's professional disciplines up on this dais. In order in which they're going to speak, each of them will be making 5 to 7 minutes of introductory remarks, and then we're going to, I'll start the question and answer process in a way of getting the room going, and then we're going to look to you for additional Q&A. If more questions don't emerge, I've got a list of questions here, some of which have to do with privacy. So starting at all the way to my right, let me introduce David Hoffman. David is the Director of Security Policy and he's the Global Privacy Officer of Intel Corporation. I'm not going to spend a lot of time going through biographies because that's all available to you, but he is in fact the Director of Security Policy and he's the Global Privacy Officer at Intel, which means that he's in one of the most important privacy positions in the world. He joined the company in '98 as Intel's e-business attorney. He has been, he's worked both here and in Germany as Group Counsel of Intel's European Legal Department. So I would say that he has an absolutely unique perspective, both from the American and European side of this thing. Sitting next to him, we're honored to have Shannon Coe. Sharon is the team lead for data flows and privacy at the U.S. Department of Commerce and within the Commerce ITA, the International Trade Administration. She has been a member of the team that's been negotiating and implementing the newly announced EU-US Privacy Shield framework, which is coming into force now, and you're going to have a lot of questions for her. Very prominent background, used to be an attorney at Sullivan and Cromwell, which is one of the most galactically influential and important law firms in the solar system. Sitting next to her, would you agree with that, is Grant Waterfall. Grant is with is the privacy and is the cybersecurity and privacy strategy leader at PricewaterhouseCoopers. He's a partner on their international assignment from PwC in the UK London office. He's based in New York and is the risk assurance, cybersecurity, and privacy strategy leader. He's been at PwC for well over 20 years. He's held a number of positions in firms in the US and in the UK. Over the past 7 years, he's been responsible for building and leading the UK cybersecurity and IT risk assurance practice and developing Pricewaterhouse's digital practice, and he's also been an advisor in a number of capacities to Her Majesty's government on cybersecurity and privacy issues. Joining us as well is Siobhan Gorman. Siobhan, a former journalist, is now the director in the Washington, D.C. office focusing on cybersecurity and privacy at the Brunswick Group. So she is now one of those people who is helping clients understand the implications of cybersecurity and privacy issues. Siobhan served previously as a very prominent reporter at the Wall Street Journal, at the Baltimore Sun, and at the Washington Post. So she is a reporter of record. Last but not least is Jaap-Henk Hoepman. He is a real, actual egghead. That's right. He is. He's got the look. He is a true and honest-to-God big scientist, genius geek. He is a computer scientist. He is a senior specialist in in security, privacy, and computer science, and he is the direct scientific director at the PI Lab in Holland. So we have anchored this with a group of people who have everything from policy and legal understanding to understanding how this is going to be reported and communicated, and those who are absolutely at the center of the development of the technology that makes all this very interesting. I don't know exactly what they're going to say. We have talked about what they're going to talk about. Among the questions that I am hoping they will discuss, and I'll just read off a list of things that I think they will be addressing, but if not, hopefully you will pick these up. The privacy shield clearly changes things, but in what way? And what makes it likely that some future challenge won't invalidate it and cause it to encounter the same problems that Safe Harbor have? What do the events regarding Safe Harbor and Privacy Shield mean for political, economic, and maybe diplomatic relations between the U.S. and EU? Does the agreement on Privacy Shield reflect common values, common interests in the international system? Or does this whole debate reflect perhaps a break in the interests that form the foundation of the North Atlantic Alliance as we've known it? Are there any technology implications arising from Privacy Shield? What research and development do we think is going to be necessary to make Privacy Shield work? And lastly, given the likely success, at least one hopes, of Privacy Shield, is there any extensibility of Privacy Shield to other regions, to other countries, to our relations and Europe's relations with other countries around the world? Can the precepts of Privacy Shield become part of the normative approach that then underpins the international system? We're not by 2 o'clock or 2 o'clock going to get through all of this, but we may touch on some of it. With that, I'm going to turn this over to Mr. Hoffman. I'm going to ask that you allow each of the panelists to go through the comments that they'd wanted to make, and then ask Q&A after the last of the panelists have spoken. So thank you very much, and over to you.
Thank you, Sam. So what I'm going to try to do in just 5 minutes is to take a very complicated legal situation that we have and try to simplify that to provide a bit of a grounding. I think if I wanted to take it all the way to its most simple form, I could just say that this is completely screwed up. But we're going to do it in a little bit more detail than that. I want to go back and provide some grounding first of how we got this. So first, I think we want to go way back to the 1970s here in Washington, D.C. In the aftermath of the Church and Pike committee hearings, we have a situation where there's a great deal of unease and concern about government collection of data and when governments would hold data about individuals. That results in the Health, Education, and Welfare Department creating a document that provides recommendations that include something that become known as the Fair Information Practice Principles. That's really important to think about. That ends up being the foundation of how modern data protection and privacy law is created. Following that in 1980, the Organization for Economic Cooperation and Development takes that work that HEW did. They then create the privacy guidelines that ratify that with a requirement that OECD member countries should be adopting laws to implement those guidelines, which include their version of the Fair Information Practice Principles. There's 8 principles in that. There are things like collection limitation, use limitation, purpose specification, data quality, accountability, security safeguards. And so you get the concept very high level with some guidance on how to implement that. The next thing that happens is that the European Union then looks to implement those OECD guidelines by creating a law that complies or follows those individual 8 principles. they end up coming up with something called the Data Protection Directive. And now we get very close to what we've got here. A couple of important things to realize about the directive for this particular situation. Number one, it's a directive, not a regulation. In European law, what that means is it's directing each member state to create their own law that is roughly in compliance with the directive, but it can be a floor, not a ceiling. So they can go above and beyond. They can actually implement in different ways if they want. What you end up with is all of individual member states having slightly different implementations in many ways of the directive. One of the provisions that they put in to try to capture the principles is what they call a restriction on international data transfer. You are not allowed to collect personal information or personal data as it's defined in the European Union and transmit that outside of the European Union unless you meet certain requirements. One of the ways to meet those requirements, and I think some of the other panelists will get into other means, is what's called an adequacy decision. That has always been thought to be that the European Commission would do an evaluation of an individual country, take a look at their structure and their law, determine whether there's adequate protection being provided by the personal data, deem that that country is adequate, and then allow the data transfer. And so the US then entered into negotiations with the European Commission to determine whether the US system could be deemed adequate, and that resulted in what was called as the Safe Harbor Agreement, where they created a structure that allowed companies to be able to certify then with FTC oversight to certain principles, once again, grounded in those fair information practice principles. We all lived within that construct, used that, Intel used it to be able to transfer personal data for over a decade, and then a young graduate student in Austria by the name of Max Schrems decides that he doesn't think that Facebook, a company that is transferring data under the safe harbor, is actually in compliance with their obligations. He complains to the Irish Information Commissioner. The Information Commissioner comes back and says, I don't have authority to investigate. They're in compliance. They've certified for the safe harbor. They're in compliance with the safe harbor. I'm not going to investigate. Max Schrems then sues the Information Commissioner to the Irish High Court. The Irish High Court says, well, we're not sure whether we actually have jurisdiction to interpret, or I'm not sure we should be, that the Irish High Court should be interpreting European law in this context. So they refer questions to the Court of Justice of the European Union. One of those questions is then interpreted by the Court of Justice is, does the Irish High Court and the Irish Commissioner have the ability to analyze one of these transfers even if a country has been deemed adequate, similar, and the adequacy here would be that safe harbor agreement. The Court of Justice then issues an opinion where they not only say that yes, just because there's been the agreement put in place and just because of the language of the directive, that does not remove under European law the ability for the information commissioners in the individual countries to be able to investigate that. They go further and say that the commission decision to allow the safe harbor to operate is invalid because of the Snowden disclosures, and obviously they didn't have enough information about what the actual protection of personal data was here in the United States. The one thing I want to set up just to conclude in the stage setting is the reason why that was so shocking for everybody is the directive itself, the OECD guidelines, all have always just been around the managing and processing of personal data by commercial enterprises. It hasn't touched actually law enforcement access or national security uses. It's actually carved out of the directive. What the Court of Justice did is they said, even though that's carved out of the directive, we are actually deeming adequacy, meaning that, and they introduced a new term called that the framework has to be essentially equivalent. And it's not just to the directive, but it's to the overall framework, which in Europe would also include the Charter of Fundamental Human Rights, as then interpreted by the courts there. And that's where we are at this point of trying to determine how to proceed with that ruling.
Thank you. Shannon?
Yes, thank you, David. I thought I would give maybe also give an overview, in particular focusing on Privacy Shield and how Privacy Shield came into being. As David outlined, we had the safe harbor that was developed between the Department of Commerce and the European Commission back in the late 1990s. That came into effect in 2000. It was, it grew from, quite a small program to up to, at its peak, 4,500 companies were participating in the Safe Harbor framework. This reflects not only the success of the program, but also the importance of data flows for transatlantic commerce. Which then brings us to the ECJ case that David referred to. Well, actually, stepping back even a little bit further, in the fall of November 2013, the Commission released a report that had 13 recommendations for ways to improve the Safe Harbor framework. This report was a result in part because of the Snowden disclosures and national security surveillance issues, but it also had a number of recommendations for enhancing and improving the protections on the commercial side. So the obligations that companies undertake when they sign up to the Safe Harbor program for processing data. So in response to the Commission's report, we entered into consultations with the Commission in January of 2014. And for over 2 years, we consulted and worked to address those recommendations and strengthen the Safe Harbor. During that time, the ECJ decision came out. That was in October 2015. We continued to look at, so now we were not only working off the Commission's recommendations and advice from the Article 29 Working Party, but now we also had the ECJ decision that set forth, while it didn't invalidate Safe Harbor itself, it didn't undertake that analysis, it certainly set forth a standard for which it would view any future frameworks as it relates to the requirement, adequacy requirement. February of this year, we reached agreement with the Commission and we released the EU-US Privacy Shield. Just while we're on the aspect of timing, I just want to note, while we did reach agreement, we did release the text of the agreement. We are currently in the approval process on the European side, and so Privacy Shield is not yet a valid mechanism to use for data transfer, and we're going through the process on the European side now to have it adopted, and then it could become a mechanism that companies could sign up to and use for the transfer of data. That's sort of the overview of the timeline of where we were and where we are now. So maybe focusing for a few minutes on the Privacy Shield package and what it represents. If any of you have had the opportunity to look at the Privacy Shield package since it's been released, you will notice that it is quite a substantial document, and comparing it to the Safe Harbor, it is significantly, or more papers there than reflected in the old Safe Harbor agreement. And this, it's a complicated agreement. It represents a number of pieces, so I find that it's helpful to provide an overview of what all of those different pieces are, how they fit together, and what it means for privacy and for companies. So, the Privacy Shield package itself represents the 2.5 years that we worked with the Commission to address the concerns that they had, and then also concerns that were discussed in the ECJ decision. And I think to make it digestible, it's helpful to look at there are really 3 pieces to the package. There are the principles and the obligations that companies undertake when they sign up to the program. The second piece relates to obligations made by the U.S. government with respect to oversight and administration. And then the third piece gets to the description of the legal framework for government access to data when it's in the United States. So maybe looking at each of these pieces and highlighting a couple of elements. First of all, it's important to note that like the Safe Harbor, the Privacy Shield is a self-certification system, so companies voluntarily sign up to participate in the program. But one, I think, very important element about that I think is often misunderstood is even though it's a voluntary undertaking, once undertaken, it is legally enforceable. And it's legally enforceable by the FTC or the Department of Transportation for a handful of companies that are in the Department of Transportation's jurisdiction for privacy issues. So, and I think another element that you'll notice that's familiar from Safe Harbor is there are core privacy protective principles that are still there. What we did in our consultations was really build on those universally accepted and acknowledged, privacy principles and enhance those protections. And just again to highlight some of those changes for companies, there are new obligations to enhance notice provided to individuals regarding the processing of their data. They not only have to be providing more information about what's happening with their data, but also their rights under the Privacy Shield. Their right to access the data, their right to access dispute settlement if they have a complaint. There are also new obligations related to transferring data from a Privacy Shield company to a third party. This is to enhance protections that stay with the data even after they leave a Privacy Shield company. This is very important element to increasing the protections that are provided under Privacy Shield. And then, just another element, to notice is that we have, as I mentioned, enhanced options for redress. So we have introduced a number of new avenues for individuals if they have complaints to pursue and to make sure that we're really, that all complaints are addressed. Just maybe highlight a couple of points on increased oversight. The Department of Commerce will administer the Privacy Shield as we administer the Safe Harbor program. We have committed within the framework to an increased role here, oversight, increased transparency, and also very importantly, increased cooperation with EU officials, including data protection authorities in the member states. And finally, just mentioning again that there's that third piece where we have the explanation from our intelligence community, from our law enforcement community that provides an explanation of the legal framework in the United States for accessing data for law enforcement and national security purposes. And there are a number of, I could go on for a lot longer about all the different elements, but I really just wanted to highlight a few of them, of the new things that are reflected in the new agreement. As I mentioned, we are in the approval process now on the European side. We, 2 weeks ago, had the release of the first part of the process was the Article 29 group, which is made up of all the data protection authorities in the member states. They released their opinion on the Privacy Shield. We're reviewing that now. The next step in the process is the member states will vote on whether to adopt the agreement or not. They are meeting this week. They're then also set to meet in May, and the expected conclusion of the process is June, at which point we hope to flip the switch on Privacy Shield, meaning turn it on, allow companies to start signing up for the program, recognizing that since Safe Harbor was invalidated, that we've been in this period of legal uncertainty for companies, and that there is a motivation to get Privacy Shield up and running to bring people into the new system, or companies into the new system, and allow them to start putting those privacy protections in place and then using it as a mechanism for receiving data. So since I've been flagged already, I will stop there, but look forward to any questions that you have.
Shannon, thank you. Very informative. And Grant, to you.
Sure, thanks, Sam. Thanks for inviting me, and it's a pleasure to be here today. My role in PwC is to lead our strategy or set our strategy and lead set strategy and lead our global cybersecurity and privacy practice. And in doing that, I serve a lot of companies, and I hear a lot of what companies are doing around cybersecurity and privacy, including what's going on now around the Privacy Shield. What I'm not, however, is a policy expert like some of my colleagues here, or a legal expert, so I'll defer to them for some of that information, but certainly have a good perspective on what companies are seeing and how they're grappling with this. So really what we're talking about here is EU-US trade in the digital age. And really we can't afford to have any uncertainty in that. Because if we do and we get this kind of stuff wrong, we will stunt economic growth in the digital age where everything is about data. And more specifically, we're dealing with data handling and how companies build trust with their customers. So, you know, if I look now to this Privacy Shield, if it's adopted, I think it does bring back, and certainly my clients feel that it would bring back some certainty to this situation around data transfer across the Atlantic. And also it helps to build trust again with that customer community between companies and their consumers, because it really does put some of the control back in the hands of the consumer. So it gives a shift in that direction. If I think a little bit about what I'm seeing my clients do and what companies are doing at the moment, you know, it's interesting to note that the vast majority of companies that were under safe harbor, which was mentioned both by David and excuse me, I've forgotten the name, David and Shannon. If I think about what I've seen under that, it's the vast majority were data processes in a B2B context. So, you know, we're looking at a specific group of companies, and if I look at those companies that were transferring data across the Atlantic in a B2B context, I expect most of them will look to adopt Privacy Shield if it is adopted. And the reason for that is it's just likely to be pushed down the supply chain. And especially as we see much greater focus around third-party risk management through regulators, I expect it'll almost become the norm to say, you know, do you have compliance with Privacy Shield? The other thing I think we'll start to see is companies getting a little bit more proactive around this. So you'll see some companies who want to get on the front foot thinking they can use Privacy Shield as a marketing device. And you know, if they do that, we'll see them look to make public declarations to instill trust in their customer base. And that could be across all sorts of companies, whether it's the B2B environment, try to win more contracts, or in a B2B context. And we have seen Microsoft take a lead position around endorsing Privacy Shield even ahead of its adoption. I expect we'll see some other companies go down that route because this trust dynamic between companies and their consumers, their customers, is going to become so much greater. But all companies are going to need to think about what choices they take in this regard, and it's not entirely clear for all companies. You know, if you look at the B2B data processor company, maybe it is reasonably clear. If you look at B2C, and we look at companies that potentially would just be worried about transferring personal data because it's their own company HR data into the US, there are a bunch of choices here, and depending on the sort of data that companies have, you know, where it is, what sort of data it is, and how it's used, they will have different considerations around the mechanisms that they use in terms of the data transfer. Certainly the companies just transferring HR data may choose other approaches. I think then companies also need to really think about the trust dynamic that they have with their customers. So what is the value and what are the influences of trust between companies and their customers? And very few companies have a true understanding of this. You know, if you think about an extreme example, I suppose, if you're Ashley Madison or you're a retailer, the expectation of how you protect consumer data is quite different. That is an extreme example, but you would expect that every company is going to have a slightly different dynamic there. And in order for them to make the choices around how proactive they are, how much money they spend, and what mechanisms they choose to deal with this transatlantic data issue and broader privacy issues will depend on them really having a good understanding of that. So to conclude, I would say ultimately, so companies need to make a choice, but ultimately where this is all moving to is that the businesses will need to put in place a programmatic approach to really getting proof at an operational level that they can comply with privacy and consumer protection requirements. Now, this is new in my books in many ways, because if you look at some of the previous regimes in place, if you look at Safe Harbor, which was mentioned both by Shannon and David, my experience with Safe Harbor was it was primarily a tick box exercise, and what it had become that in many companies. And even if you look at one of the other mechanisms that companies use, which is model contracts, the test there is a signed contract. Although it might intend to have implemented operational adequacy, the test still remains a tick box. So I think as we move into a Privacy Shield environment, certainly the intent behind what we're reading in Privacy Shield is much more towards that operational adequacy, programmatic approach, which is contained in the GDPR, which is on its way down the road as well. And I think the debate is going to need to be around how companies do move to that more programmatic approach and do embed operational adequacy in their businesses.
Very good. That's going to be a lot to digest. I think I'm going to have a follow-up question for you. Siobhan.
Well, that's actually, I think, almost a perfect handoff, because while Grant is looking at how companies are actually going to sort of manage the mechanics of it, we're taking a look at how companies manage the reputational issues that this brings. And sort of putting both my journalist and consulting hat on, I spent a number of years, probably the better part of a decade as a journalist, looking at privacy and surveillance and intelligence and national security issues. And the revelations of Edward Snowden shifted that landscape like certainly nothing I had seen. And it's interesting to me that we're still seeing those reverberations, this many years later. We're almost 4 years later, or 3 at least. So Snowden, I think, helped push ahead in a pretty significant way this debate over kind of this inherent tension between privacy and security. And as others have pointed out, when you look at it from the perspective of a business, it's not just privacy and security. Obviously, businesses would want to be supportive of those things, but they also have to think about making sure that they're doing what is best for their business, their investors, and their key stakeholders as well. And businesses are navigating now among a whole host of different types of privacy requirements. There are more than 100 countries that have some kind of data protection law in place. Right now, obviously, the EU discussion is the most prominent, but as companies try to think about this, they need to make sure that they don't over-rotate in one direction or the other, because overall, if you're trying to manage a global reputation, you need to make sure that you are doing it in a way that is consistent both with the law, but also sort of your business prerogatives. So one thing that they're looking at right now, obviously, as you have the EU debate underway and the negotiations with the US, is how they're going to straddle the EU sort of preferences with the US's approach, which has historically been, certainly less prescriptive in terms of how companies need to show that they are managing data privacy. They're basically gonna have to reconcile this tension, and this the Privacy Shield is gonna force them to do that. As they do that, they're also gonna have to figure out how it is that they position themselves. And I wanted to offer up just one really interesting case study because it's recent. Microsoft, which certainly had its day in the sun, so to speak, during the Snowden revelations, has been working on how to position itself in this debate. And they decided to take a pretty proactive approach when it came to Privacy Shield. There are not many US companies that have really taken a public stand. But they announced their sort of general support for the Privacy Shield agreement and certainly the approach it takes. And they just did it a few days before the Article 29 Working Party announcement, and they did it in sort of a blog post from their vice president of EU and government affairs. So they were doing it in a way that was definitely trying to send a message. They used, timing to their advantage. And, they were certainly able to get a fair amount of public attention from it, as well as certainly getting the attention of the policymakers they were trying to influence as well. And that announcement signaled to, I think, a lot of people that companies are kind of struggling with this, and they do now feel that they really have to take a position. And I don't know that 5 years ago companies would feel that they would need to take a position publicly, at least on an issue like this. But at this point, particularly U.S. companies, but I imagine companies, certainly multinational companies, are now post-Snowden in a situation where they need to prove their privacy credentials, I think, in a more significant way than they might have had to before, particularly as they look to reassure their European customers and customers elsewhere around the world. And what was interesting about Microsoft's position was not only that they took a position, but their rationale for the support of Privacy Shield publicly was not actually the rationale that Grant was providing, which assuredly factored into their thinking, but they weren't talking about it as a business decision, that we need certainty because, we're now looking at more than $260 billion in transatlantic commerce that's moving from the US to the EU every year, so obviously there are major business implications. No, what Microsoft said was, we support Privacy Shield because of the way that it promotes transparency and individuals' rights to privacy, which was just it was a different lens through which to look at it than other businesses might have. And I think that that's also a signal to businesses that how you frame your position on these kinds of policy issues like Privacy Shield and the others that are kind of within this shifting European privacy landscape really matters. Sort of where you put your point of emphasis really matters. And I think Microsoft, in this case, has provided a window into how that conversation may change, that you may start to see, particularly from technology companies, an effort to try to frame this as sort of a pro-privacy stance. Now, when Microsoft is a careful company, and so when they actually, the way that they phrased their support definitely was done in a careful way. I think they said that, they called Privacy Shield a strong foundation on which to build. And they also talked about their own efforts to promote privacy and transparency. So, certainly this wasn't probably a 110% endorsement of Privacy Shield, but it was a strong supporting statement. And I think that what you're going to see over time is that particularly some of these larger technology companies that found themselves kind of caught up in the Snowden revelations are probably going to have to take a position simply to reassure their customers. But exactly how to position themselves is really challenging. I think that you're still seeing very different positions voiced in the U.S. and Europe. This morning, or I guess it was just yesterday, President Obama was in Germany making the case for kind of weighting the national security side of this debate a little bit more heavily than certainly he felt that his audience was. He said, I want to say this to the young people who value their privacy and spend a lot of time on their phones. The threat to terrorism is real. And so he is still kind of trying to weight national security and make sure that people understand those implications. So it will be interesting to see, especially as you have the General Data Protection Regulation and the right to be forgotten and so many of these other issues kind of coming to the fore, particularly in Europe, how it is that other companies look to follow suit.
I can see a follow-up question coming to that. Mark, thank you. All right, and last but not least on the panel, Dr. Hoepman, Jaap-Henk, you go.
Thank you, Sam. It's a pleasure to be here, and it's an honor to be called an egghead, whereas back home in the computer science department, people increasingly think that I'm a policy wonk, so that's sort of interesting.
Geek, wonk.
Yeah, well, it's the same kind of stuff in the end, right?
All words.
Yeah. So allow me to provide a little insight into the European perspective on the issue here. I've been talking to a few people in Europe the past months actually regarding Privacy Shield, and I've actually heard a variety of opinions there, ranging from, well, it's basically same meat, different gravy, through, well, yeah, there's significant improvements, but there's over safe harbor, but still essential elements missing, all the way down to, well, I don't think this will stand in court against the European Court of Justice if a second Schrems-like case is going to be brought in front of it. And actually, I've even heard somebody say, well, basically saying that the opinion of the data protection authorities is basically irrelevant here because they would never dare to prohibit the sale of, say, iPhones in Europe because they would, for some reason invalidate the clause in the Data Protection Directive or the upcoming regulation. So I think that's interesting. It was already said that the final blow to safe harbor was the whole issue of surveillance in the ruling by the European Court of Justice. Personally, I don't think that this surveillance thing is really a red herring because there were already serious concerns about safe harbor before that ruling, and there were already negotiations about a different phrasing of the safe harbor that now turned into the privacy shield. I think the real thing to discuss is the remaining issues that are out there perceived by the Europeans regarding the current phrasing of the privacy shield. And I'm going to base most of what I'm saying on the recent opinion published by the Article 29 Working Party about the shortcomings. And really what they have been doing is, as what David already mentioned, is taking this definition of what adequate level of protection really means in the context of this Data Protection Directive, saying that there should be essentially equivalent kind of protections provided for. And if you take that point of view, which is a really strong point of view, the Article 29 Working Party identifies a few problems with the current phrasing of the privacy shield. One of them is the lack of regard to the data retention principle. So in European law, whenever you process data, you also have to have like strict limits on when you discard the data. You're only allowed to have the data for the period that you're processing the data for the intended purpose. And once the processing is done, once the purpose is done, then you have to delete the data. This is not very clearly expressed in the privacy shield. Another aspect that's important in European law is the protection in case of automatic decision making based on personal data. Let's say colloquially said profiling. And this is really a big thing when we look at the recent developments in the area of artificial intelligence and big data. There have been some issues with the complexity of the redress mechanism, and if you look at the redress mechanisms in place in case of surveillance, there may be problems for Europeans to have any standing against things that happen, because you have to show, at least under US law, you have to show that you have sustained direct injury or harm, and that is typically not the case or very hard to prove. And then finally, there have been some doubts regarding the independence of the Privacy Shield ombudsperson that is there to oversee any kind of complaints and especially oversee the surveillance activities. Finally, and I think then the whole surveillance issue comes back, that the US government has admitted and basically said that there's going to be limited bulk surveillance for 6 specific purposes as defined in the additional documentation underlying the privacy shield. However, according to the Article 29 Working Party, massive and discriminate surveillance of individuals can never be considered as proportionate or strictly necessary in a democratic society. And that is one of the reasons why certain people say that if this privacy shield is brought back to the Court of Justice, the Court of Justice might still rule against this. I think looking at the future, if we again take this definition of adequate protection to mean that we should have like basically equivalent level of protection compared to the European framework, then it's interesting to see that we will have within 2 years the new regulation will basically be enforced in all the European member states, and the new regulation really stipulates additional requirements on the processing of personal data compared to the directive on which the current, say, privacy shield is based on. One of the things is the right to data portability, so the right to be able to change services and take your personal data with you and then use that data for another service. The other one is the need to carry out a privacy or data protection impact assessment. And finally, last but not least, the requirement to comply with the principles of privacy by design and privacy by default. And especially the latter topic is really something that my heart is very close to as an engineer. And so I'd love to discuss that with you guys.
Wow. Okay, talk about drinking through the proverbial fire hose. I want to start this off by asking two questions, and then I'm going to try and open this up to the audience. The first question is perhaps a little more existential. Maybe it doesn't have a good answer. But the sort of downfall, I think, of Safe Harbor was based on shifts in the political and social sentiment in Europe that undermined the trust, the level of trust relating to American data privacy standards. Do we feel that the political and social environment in Europe is sufficient to be able to support adequate implementation of Safe Harbor? That's one of the two questions I want to ask. And for efficiency, let me put the other question out there. And I think and you're going to be the one I'm going to focus on this, is the technology, what technology are we going to have to develop to be able to have an effective, essentially, privacy by design, privacy by default? How are we really going to be able to manage things, for example, like the European right to be forgotten? Does the technology exist, and what are we going to have to do to our research and development agendas to get that? So before we get to that question, though, I'd like to talk about the political and social underpinnings and sentiment in the Europe and perhaps the United States. Are they sufficient to support implementation of Safe Harbor? Anybody want to take a shot at this? David, you look like you're ready.
Yeah, I'll just say something, and then maybe others, maybe we can go back and forth a little bit. I think we've got a particularly problematic environment, and it's bigger than just implementation of the Privacy Shield, but the Privacy Shield is a portion of it. For us to have come full circle from concerns in the U.S. about government collection of personal data in the 1970s to, once again, concerns about government collection of personal data. But from a European perspective, what's interesting about that is the Safe Harbor and then the Privacy Shield is just a mechanism to transfer data between Europe and the U.S. There need to be other mechanisms for the Europeans to transfer data to other countries that they do business with. So people here talked about a lot of the personal data that's transferred is for business-to-business perspectives or uses. I asked the question, I said, well, if people are going to continue to say that the U.S. system of oversight and controls for data collected by our law enforcement intelligence community are not sufficient, how can the Europeans justify doing business with a company in Russia, in India, in Pakistan? You name it, Iran? So there are legal fine points there, and we could get into the legal fine points, but this is an issue that's bigger it's a global issue about what's the intersection between fundamental human rights like privacy and collection by law enforcement intelligence agencies from corporate entities. I think the right solution there should be, from a policy perspective, to say, don't punish companies because governments have improper mechanisms of oversight for their collection of data. That should be dealt with by government-to-government discussions about putting the right controls in place there, not slowing down business.
Shannon?
If I may make a couple of points about Privacy Shield specifically, and what we've really heard since Safe Harbor was invalidated, we've been in this period without a mechanism, is how important it is. It's not only important in the US, it's so important in Europe. So much of our trade and investment relationship is, there's this data flows underpinning that, and Siobhan mentioned the $260 billion in digital services trade, but it's even broader than services. I mean, really, in 2016, data touches all aspects of the economy. So, one thing that I think, if we want to look at a silver lining out of this whole situation, is that we do realize, and there's a realization on both sides of the Atlantic, how important this is, and it's important to get it right. And maybe to highlight, a couple of advantages that Privacy Shield provides that we've also, had an opportunity to explain in our outreach in Europe, and that I think is really starting to resonate with folks in Europe, is that, there are other mechanisms for transferring data out of Europe. Primarily, we're talking about model contracts or binding corporate rules. But Privacy Shield offers a number of advantages over those mechanisms, which again, I think has sort of come to light in this period where we didn't have that mechanism available. One is that there is increased transparency that doesn't exist under the other mechanisms. Companies, when they sign up to the program, will be listed on a website as participating in the program and as receiving data from Europe. I think that's something that you don't see with the other mechanisms. There's also, very importantly, the oversight in the U.S., government oversight, that you don't have with model contracts or binding corporate rules. We have committed to overseeing not only in the administration, we've also committed to vigorous enforcement on the FTC side. Again, Privacy Shield offers this legal hook, which the other mechanisms don't provide. So just a couple of points to say that, I think there is a shift. There's a recognition of the importance of data flows. There's also a recognition of the importance of the protections that the Shield does provide, especially as compared with other options for transferring data.
Okay.
Maybe I can sort of comment on the question that you initially posed, which I sort of rephrased like the underlying forces that are at play now in the European Union. First of all, it's important to understand that the protection of privacy is fundamentally different in Europe compared to the US. In Europe, it's a fundamental right which applies to everybody that happens to be in the European Union, compared to the protection of fundamental rights in the US, which is really only restricted. It's restricted to US citizens. It's interesting to see that with the final agreement on the regulation, you see a sort of confidence in Europe that, or a feeling in Europe that their data protection legislation and structure is a model for how it should be in the rest of the world. It's almost like an export product. That's how many people see it in Europe. And also interesting to see, and if we look at the difference in between Europe and the US, there's a difference in what I would call the trust model. In Europe, we have a tendency to trust government more than we trust business, whereas in the US it's typically the other way around. So that's also something to be aware of. And then finally, there is one of the important things in Europe, and especially the main reason to have things like a data protection regulation, is to have a level playing field. Everybody should have in the economic market, and there's the growing feeling in Europe that especially American corporations offering services in Europe are doing so in a way that is against this level playing field, because the European companies are held against the European data protection regulation, whereas the American companies have been, I would say, willingly overstepping the boundaries and the rules, trying to expand their market. And that is a sort of like underlying nagging feeling in Europe that may explain some of the sentiments regarding the Privacy Shield now.
What are some of the, go ahead,
Oh, I was
please.
just going to make one sort of brief, broader point, is just sort of a note of caution, because I've spent a fair amount of time watching the U.S. try to wrestle this issue to the ground in terms of how is it that you curb surveillance. And I mean, one thing that Privacy Shield does, which is really interesting, is a lot of the approach is taking kind of a checks and balances, redress, ombudsman, sort of putting systemic elements in that provide more checks and balances. But overall, the desire to sort of curb surveillance activities is something that governmental structures are not very well equipped to deal with because the technology changes so rapidly. And as much as businesses and governments, for good reasons, prize predictability and stability, technology goes way in the other direction. And so you just don't want to assume too much that when you create a new structure that it really is, especially around the issues of surveillance, just because the technology changes so much, that it's necessarily going to always have the intended outcome. The U.S. thought that the Foreign Intelligence Surveillance Act was really going to limit surveillance, and it turned out that the government response to that as technology changed was real different. So, you could see different dynamics, but along those lines down the line.
So do we feel that, what are we going to need to do to be able to develop what technology gaps exist in the implementation of Safe Harbor? Are we going to be able to reconcile some of the needs, for example, the need to be forgotten, and other European data privacy expectations with the technology that we have today? Or is technology's advance going to continue to undermine our ability to implement these precepts?
So I'll take a first go at that. I mean, I think there are definitely technology issues to consider here, but for me, these things like privacy by design and right to be forgotten are primarily process issues first. So companies really need to think about, how they get secure development life cycles in place and actually embed privacy in the next digital offering. That will involve technology, but it involves, first of all, changing the way you do things. Privacy impact assessments around changes in data usage before, a marketing officer goes off and does something slightly creepy with consumer data. Maybe racial profiling or whatever it might be. Those are process issues that need to be embedded. There will be privacy-enhancing technologies which come into play to help some of this, and I'm sure as the market develops and this becomes such a big issue, we'll see quite a burgeoning market for those sorts of things. But I first and foremost don't see it as a technology issue.
Just to chew on that for a second, I think it's going to be a hell of a problem. Because a lot of new digital technology is interesting because of the way it accrues, analyzes, and applies that data to making high-value decisions. Mm-hmm. So the use of that technology is designed, in fact, in explicit contravention of the idea of being forgotten. We want to forget nothing because over time, the pattern of that information, accrued with other information, derives a lot of value. All right. I'd like to open this up to the audience. I'd be grateful we'd be grateful for your questions. We would also be grateful if you would identify yourself when you ask them. So with that, please don't be shy. Or be shy but still ask questions. All right, while you're thinking of a question to ask, and there will be a short quiz after class here, so, and we are grading on class participation. And we're not grading on a curve, so we're pretty tough.
Tough professor.
Yeah,
Can I just extend the answer to the last question
Please.
just slightly? So one of the things that I've been working on in conjunction with a couple of colleagues is taking a look at the changes in technology and saying, do those underpinning fair information practice principles, do they still work? Are they still relevant? There's been a bunch of debate in the privacy community around that where principles like collection limitation and purpose specification, people say those really run in conflict with the value that we can get out of things like advanced data analytics, particularly when connected to a cloud computing environment. Why in the world would we be saying that limiting the collection and limiting the amount of data that we would have access to is the right solution? Why wouldn't we get rid of those fair information practice principles and look towards other types of protections? And so we've written a paper, which I have copies with here if anybody's interested, called Rethinking Privacy, which takes those fair information practice principles and says for exactly the kinds of issues we're talking about here, that they're still relevant, that collection limitation is still important, but we need to put more emphasis on a couple of principles that have not been implemented well enough. Things like use limitation, really saying, particularly in an intelligence and national security context, that collecting information because you're furthering a counterterrorism purpose, that's great. Should you be able to use that then also to catch tax cheats? I would say, look, if you're going to make the argument for collecting more data because you're stopping terrorism, limit your use of the data just to terrorism. The other principle that I would advocate is accountability. That principle is all about how do organizations demonstrate that they're acting responsibly and fulfilling their obligations. This is, I think, something we really need to focus on here in the US and then hold this out as a global norm. We'd have to ask the questions with regards to national security. What are the roles of the congressional oversight committees? How do they function? Are we comfortable with how they're holding our own agencies accountable? And can we hold those out to the Europeans and say, you should feel comfortable with this, because we may not have a concept of openness to everyone, but we do have openness in our representational democracy to our elected officials.
And to comment on what you just said, David, and your original question, Sam. I think if you look at privacy by design, it's not so much a technological issue. Most of the technology is out there. It's a matter of applying it. But I think one of the main reasons why it is not applied is things like business models. I mean, like you said, we're collecting data for a purpose. And maybe it's revenue, maybe it's government efficiency. All these things are really strong incentives not to do privacy by design, but do exactly the opposite. Also, I think what you just said about looking back at the fair information principles and rethinking about how could you actually protect privacy better given the developments of technology. I know a few people in our lab have been thinking about instead of looking at limiting collection, maybe looking at the use of the data and thinking of it and in terms of anti-discrimination kind of rules, like how do you fairly use the data? And another approach that we are going to investigate a bit further is to think about the whole idea of duty of care. I entrust my personal data to you. You have to be careful with the data, whatever careful means, and that is something that is very interesting to explore. The other question you had was really aimed at surveillance and the role of technology there. I think there's actually considerable work to be done in terms of more or less fundamental research to figure out ways where, on the one hand, we can protect our fundamental rights, and on the other hand, allow intelligence services and law enforcement access to data under very specific conditions, but making sure that those conditions are more hardwired into the technology. Only oversight, only accountability may not be enough, because there's really a difference between looking at Eastern Germany in the 60s, 70s, where yes, you would have to they actually managed to have a lot of Stasi agents out there, but there's a limit to the amount of resources you can spend to do surveillance. The problem is that with the current technology, with everybody having a phone in their pocket, they're basically having their own Stasi agent in their pocket, to say. Surveillance becomes very, very cheap. And now, is there a way to design technology in such a way that the effort increases linearly with the amount of people you want to survey? And that's a fundamental research question, actually one that we're studying in our lab.
To poke further, there is it could be said that there is a public good in the continued accrual and essentially and memorization of information as we move. My own group of people at ICF, we do work at the Department of Energy. We're looking at how the smart grid can be both made effective and secure. But the smart grid depends, and smart infrastructures depend on the accrual and predictive data analytics to manage resources in a transportation system, in a financial management system, in an energy system for bulk power, for everything else. How in Europe are we going to reconcile the fact that to make our infrastructures more efficient, we're going to have to accrue a lot more information and allow the utilities to manage that information in a way to optimize the allocation of limited resources, like energy and transportation. Siobhan?
No, I think that's a really important point, and I think it also goes beyond utilities. We have a research section at Brunswick, and they do this investor survey every year. And every year we continually see increases in investors asking saying that it is very important to them for their investment decisions to know how a company is going to monetize the data that it is holding. And so that creates a business incentive to hold and make the most of the data that you have. And that's another tension that companies have to struggle with.
Again, I'm going to open this up. Participants, please feel free. What questions do you have in the time that remains? There must not be any Georgetown students in this room, because my students always have questions, mostly ones I can't answer. I see a question in the back. Please. If I understand your question correctly, and I'm going to put it to the panel, what are the implications for this agreement to countries beyond the United States and beyond the EU? Could this become part of the norms that are adopted by countries outside of that relationship? Does that capture your question? Okay. Guys, Shannon, you want to take a shot?
That's a quick one for me. So I think it's important to start off by noting, of course, that this is a bilateral agreement that we have to meet EU legal requirements. So, of course, it is between the U.S. and the EU, at this point. But you raise a good question about what influence could it have elsewhere. And I can tell you that we have, received questions from other of our trading partners. There's a lot of interest, and folks the world over are interested in watching Privacy Shield very closely. I mentioned that Privacy Shield itself is based on a number of core privacy principles that are accepted throughout the world. I want to highlight another program actually that my office is involved in that is similar in many respects to Privacy Shield, in that it's based on a set of privacy principles that are universally accepted privacy principles, and it's also a self-certification program. And that's the effort that we have in the APEC arena. And these are, it's a program, the Cross-Border Privacy Rules program, that was developed within APEC and is growing, and we're trying, we have 4 economies participating now, but certainly the vision for the future is that it would encompass many more economies and be a framework, privacy protective framework that would be applicable elsewhere. And I think that demonstrates the usefulness of this type of mechanism, that Safe Harbor really was the leader there. You have principles, companies sign up, they're enforceable. So we do see that type of effort we're undertaking to mirror that elsewhere and build on it. So.
I was actually going to ask a similar question as to whether or not this could become extensible. Do we see any uptake in larger international institutions? I don't know who's really governance for this. The International Telecommunications Union. Where would this begin to express itself on a broader multilateral basis if it occurred?
Anywhere but ITU.
Anywhere but ITU. Is that because of the weather in Geneva?
No, that's better than Holland, so
No.
that's not the reason.
Okay. Other questions? I'm glad I came prepared. There is a sense, at least one former director of Central Intelligence, and I won't say which one, although I think he used to be director of the National Security Agency, who felt, and this was a few years back, that perhaps the political relationship between the United States and Europe had eroded such that it wasn't the true partnership in today that it had been in the past. What do the developments around Privacy Shield and Safe Harbor imply for essentially the North Atlantic relationship? Is the North Atlantic relationship being reset and strengthened, or does this represent a view that the political and geopolitical interests of Europe and the United States are moving in separate directions? Is this reflective of those things? Or again, is it reflective that having gone through a more strained period that we're seeking to gain a common approach, and that given that cybersecurity is an issue of national security and international security, are we trying now to reestablish common ground? Or does this mean that, is this in essence an agreement to disagree? Please.
Yeah, I mean, I think you can make the argument for either one, but I think the side I come down on is this is an opportunity for us to come closer together. So I still lived in Germany. I lived in the UK for a while for Intel. I go back to Germany quite regularly. Last time I was back, I said, I was asking a question that was particularly focused on the German data protection authorities in the individual Länder. And I said, they depend upon Gazprom to deliver natural gas from Russia. I said, how in the world, if they take the same approach to the transfer of data to the United States, are they going to be able to still have Gazprom deliver natural gas? Gazprom has to deliver some level of personal data back to Russia, even if it's just business-to-business contact data of the agents that are acting to buy from their customers that are buying the gas. And the response to me was, when you have friends, you expect more from your friends. And that's what we expect from the United States. And it was actually said as a very respectful comment, too, in that they thought there was an opportunity for the U.S. to show the rest of the world the way certain things should be happening. I would also say my belief, after talking quite a bit with someone, many of you probably know Ben Wittes at Brookings, who wrote a fantastic book called The Future of Violence with Gabriela Blum, who's a Harvard professor. He has a theory, the world is becoming a much more dangerous place in a certain respect, that because of aspects of cybersecurity and aspects of technology, it's becoming much easier for one individual to create a large amount of harm to a great number of other people. That puts a strain on our systems of how we provide for security. We're no longer in a Cold War methodology where we know who the actors are and we just want to get access to the content of their communications. It means that we actually have to do target identification, and we know in this current environment we need collaboration between the partners that we have because we live in a global environment. When I go over to Europe, the privacy commissioners may be saying one thing, but the defense agencies in the individual member states, that's still, I think, a strong collaboration, and the citizens feel the same way, particularly after Brussels and Paris.
Go ahead, please.
Just really a quick point, just to answer your question, which is, I have to agree. I think that Privacy Shield demonstrates that we can cooperate on tough issues where we have different approaches. I mean, this is the bridge. We have common values on privacy, but we deal with them very differently legally, and we together have developed this mechanism. Not only that reflects those values and provides a workable mechanism, but it also provides for a platform continuing discussion on these issues and collaboration that doesn't exist outside of that. So I do think that it demonstrates that we can work together, and we want to continue to work together on these issues in a very important way.
Fair enough. I've been told I have to hustle people out of here by 2:05. So panelists, are there any questions that you wanted to answer that we didn't pose, or questions where you would like, as we say, to what do we say, to advance the story.
I have one. I'm wondering, given the latest sort of working party opinion, how much change one would expect now that they've sort of put forth their opinion and we're kind of moving along in the process. I mean, it's not a binding opinion, so it could be no change. I'm just wondering, for those who follow it closely, what you'd expect.
I follow it very closely.
Yes, obviously.
So, I mean, I guess what I'll say very quickly on this is that we are, have been reviewing the opinion. There are different recommendations and elements in the opinion that would require different responses, whether it's, you know, on the commission side and their adequacy decision, or whether it's something that's related to our ongoing continuing work in the annual review or other things. And we are looking to see how we can best address these concerns, and while also moving forward in the approval process and making sure that we get Privacy Shield up and running, and companies, you know, bringing their systems in compliance with the protections. And I also, maybe just a final point, which you know, we did design this as a living framework where we commit to continue to working with the Europeans, including at the member state level. So I think this is you know, it is an ongoing discussion, and we will, you know, be working very closely with the Article 29 party going forward. Yeah, I'd say that.
Please join me in thanking our panelists. Outstanding discussion, and thank you all.